Welcome to Telugu One Academy. Today we have a topic that is President of India. President of India, this is under Union government. We study this topic under Part 5 of the Constitution. President of India is from Article 52 to 78. So, under Part 5 of the Constitution, we have Union government and we have Union executive. Here, when we say Union executive, we have 5 important dignitaries. That is President of India, we have Vice President, Prime Minister, Council of Ministers and Attorney General. These 5 dignitaries constitute the Union executive. So, President of India, as we all know, we have discussed in our previous lecture that we follow parliamentary system of government, and in parliamentary system of government we have nominal head and real head. President of India is a nominal head. He is a de jure head, that is head of the state. President of India is head of the nation and Prime Minister is head of the government. President of India is also elected but indirectly. We have an indirect elections to the President of India. We have a separate electoral college, unlike the Prime Minister of India, who generally gets elected directly. He is one among the member of the Parliament. Prime Minister of India is elected indirectly, and Prime Minister of India holds a very important position. He is the part of the Parliament. When we say Parliament, Parliament consists of Lok Sabha, Rajya Sabha and President of India, because no bill introduced in either of the house will become an act without the assent of the President. So, President has to sign the bill, then only that particular bill becomes an act. So, we will discuss the various elements related to President of India. Mainly we have the qualifications, the term, the mode of elections, which is very important, and also the nature of removal of the President and various powers of the President. So, in this class we would be dealing with the President of India and various elements which are considered with President of India. So, as we have discussed, President of India is under Part 5 of the Constitution from Article 52 to 78. So, the Union executive consists of these 5 dignitaries: President, Vice President, Prime Minister, Council of Ministers and Attorney General. So, here Prime Minister is the head of the Council of Minister. Council of Minister, as we have discussed, they are the Union executive headed by the Prime Minister, and Prime Minister would aid and advise the President on various functions of the government. Attorney General represents the government in any legal cases. So, if there is any legal case, Attorney General would represent beside the government in various courts. So, we know Union executive, this probably will be a question in examination. The Union executive consists of these 5 dignitaries. So, President, Vice President, Prime Minister, Council of Ministers and Attorney General. So, the President of India, as we say, President of India is a nominal head, head of the state. President of India represents the entire nation. He just not represents any government or any party. President is ultimate power, a supreme authority which represents the entire nation. So, we also say that President of India is the first citizen of our nation, and because President of India has a very wider electoral college, not directly but indirectly, President of India has a wide electoral college that represents, that reflects the unity, that reflects the diversity of India. So, President of India acts as a symbol of unity. because President of India is not just president to any party or any state. Entire nation is represented by President of India. And President of India, any function, any administrative function should be by the assent of President of India. Even though the bill passed in the parliament, there has to be an assent given by the President. So, symbol of unity, integrity and solidarity of the nation. In the name of the President only, various functions of the government would take place. Even the appointment of Prime Minister, the Prime Minister is also appointed by the President, and various ministers are appointed by the President on the recommendation of the Prime Minister. So, President is a very important dignitary where all the major appointments are done by the President. So, this is the election procedure, how the President would be elected. మన రాష్ట్రపతి అనేది ఎన్నికల ప్రక్రియ ఒక విభిన్నమైంది. ఇట్ ఈస్ నాట్ డైరెక్ట్లీ ఎలెక్టెడ్. ఒక ఇండైరెక్ట్ మెథడ్లో మన ప్రెసిడెంట్ని, రాష్ట్రపతిని మనం ఎన్నుకుంటాము. సో ఈ ఎలక్ట్రల్ కాలేజ్ అనేది ఒకటి ఉంటుంది. వీ విల్ హ్యావ్ అ సపరేట్ ఎలక్ట్రల్ కాలేజ్ ఫర్ ద ఎలక్షన్ ఆఫ్ ద ప్రెసిడెంట్ ఆఫ్ ఇండియా. And it is the Election Commission of India which will conduct elections or which will bring elections to the President. As we have discussed, the Election Commission of India conducts election for President, for Vice President, for Member of Parliament, that is for the Parliament and state legislative assemblies. And wherever we have bicameralism in state legislative assemblies, that is councils, even Election Commission of India would conduct elections for councils also. There is no separate election machinery. It is the Election Commission of India which conduct elections for the President. And as we know, the main officer, the returning officer for the President election would be the Secretary of Lok Sabha or Secretary of the Rajya Sabha. That would be on a rotation basis. So, one term there will be a Secretary of Lok Sabha who would function as a returning officer for the election of the President. As we have know that in 2017 elections, Ramnath Kovind, when he got won to the post of the President, it was Secretary of the Lok Sabha who was a returning officer. So, we have an indirect type of elections. Now, why we have indirect type of election or indirect elections conducted for the President? As we know, Prime Minister is directly elected by the people, and why again we need a directly elected President? So, there would be obviously a conflict between two similar dignitaries, because when we say we have a presidential system in America, there the President is directly elected, and President of America is both the head of the state and head of the government. Here, the President of India is only a nominal head, and the real authority lies in the Council of Ministers headed by the Prime Minister. So, for that reason, as we follow parliamentary system of government, which is also known as prime ministerial system of government or cabinet form of government or Westminster model of government, we do not require a president who is again directly elected. So, there will be a conflict of interest between two directly elected people. So, the Constituent Assembly thought that we need just a nominal head who generally approves the bill or who acts as the head of the nation. So, we thought that indirect elections would be better. That was one of the reason. And second reason is because there is a lot of resources required for indirect elections, and we generally do not have that much of resources initially. So, we thought that indirect elections would be appropriate for electing the President. And again, we have cultural background differences also, like we have a lot of illiteracy. So, that is the reason people would not understand the process of presidential election. Again, if they get elected directly, there would be again the differences between two directly elected dignitaries. So, we thought appropriate of having indirect elections to the President of India. So President of India is elected by an electoral college. Electoral college consists of the electoral college which elects the President of India. It consists of directly elected, that is elected members of Lok Sabha and also elected members of Rajya Sabha. ఎవరైతే ఎలెక్ట్ అయ్యబడతారో డైరెక్ట్ పీపుల్తో ఎలెక్ట్ అయ్యబడతారో వాళ్ళు మాత్రం ఈ ఎలక్ట్రల్ కాలేజ్లో ఉంటారు. లైక్ పార్లమెంట్లో లోక్సభలో ఎలెక్ట్ అయిన వాళ్ళు, రాజ్యసభకి ఎలెక్ట్ అయిన వాళ్ళు, దే విల్ ఫార్మ్ పార్ట్ ఆఫ్ ఎలక్ట్రల్ కాలేజ్. అదేవిధంగా స్టేట్ అసెంబ్లీస్లో ప్రతి స్టేట్కి ఒక అసెంబ్లీ ఉంటుంది. ఆ అసెంబ్లీస్లో కూడా ఎవరైతే డైరెక్ట్గా ఎన్నికలో ఎలెక్ట్ అయి ఉంటారో వాళ్ళు మాత్రం ప్రెసిడెంట్ ఆఫ్ ఇండియా ఎలక్షన్స్లో పార్టిసిపేట్ చేయొచ్చు. సో వీ హ్యావ్ ఎలెక్టెడ్ పీపుల్ ఆఫ్ లోక్సభ, we have elected people of Rajya Sabha and elected people of all the legislative assemblies. Even the legislative assemblies of Delhi and Puducherry also participate in the elections of the president. This was later added by the Amendment Act, 78th Amendment Act 1992. The legislative assemblies of union territories, that is union controlled states. We do not say that Delhi is a complete state. Similarly, Puducherry also. So they have their assemblies. So elected members of Delhi and Puducherry will also participate in the elections of president. So the election will occur according to the proportional representation. We have a system called proportional representation. Proportional representation is here all the elected members will represent, and elected members who are elected to member of parliament, who are member of parliament and also member of legislative assembly, they get elected by a constituency, and constituency has the people. So we elect the president on the basis of proportional representation, and we also have a system of single transferable vote. Every person in the electoral college will have only single vote. They have only single vote, but that vote is transferable. That is, the voter, the member of electoral college in the presidential election can give their preference to the candidates who are contesting the elections to the president. So three main things we need to remember here. We have a separate electoral college which consists of elected members of the parliament and elected members of the legislative assemblies. Here we do not consider legislative councils where there is a bicameralism, because all the states do not have bicameral legislature, and therefore we only consider legislative assemblies. And we have legislative assemblies of Delhi and legislative assemblies of Puducherry, and thus election will be based on the system of proportional representation by single transferable vote. So we have discussed why we have not gone for direct elections, because there is a loss of time, money, and it is not necessary also where we follow prime ministerial form of government. So this is where the procedure of elections go. The procedure of elections, Article 55 discuss about the process of elections to the president. So here the elections will be held in a proportional representation by means of a single transferable vote. Why we want to have a single transferable vote? That is, we know that there may be various contenders to the post of president, and they may not get absolute majority. That is, absolute majority is more than half of the majority. That is 50 plus 1. That is 50% plus 1. That is called absolute majority to win the elections. But what if we have more than 2 contenders to the post of the president? Then, for example, if we have 4 contenders, the voter will have a single vote, but that particular voter can give their preference beside the name of other contenders also. Like for example, we have 4 contenders A, B, C, D. The voter would give his preference here. First, if there is a A, he would give 1, and then for C he would give 2, D 3, B 4, like that he can give the preference to the various contenders or the participants to the post of the president. If A gets an absolute majority at first go, if he secures the majority, that is 50% plus 1 majority, then he would win the elections. Otherwise, we will have a transferable vote. We would consider the preference, second preference, and we will add this to the preference of the first candidate who got majority of the votes. This we have a formula, we would be going into that. So, single transferable vote. Why we have single transferable vote? We could secure absolute majority in the president elections. So, this also envisages a quota system. We should have a quota system where if in first counting, if any participant do not get a absolute majority, then the quota system will come into picture. This quota system is 50% plus 1 of the votes. So, here as we know, all the states do not have equal population. So, we would give the value to the MLAs, that is member of the legislative assemblies. So, this value ensures that the population, all the population is represented equally, and that value should be equal to all the states. So, value of an MLA is, we have a formula for that. We have total population divided by the total number of directly elected MLAs. That is a formula what we have. That is, first we would consider the value of MLA. Value of MLA is calculated by the total population of the state divided by total elected MLAs into 1 by 1000. That is the formula we have. See, value of the vote of MLA is total population of the state. For example, in Telangana, we have total population of the state and then the total number of elected members. We say elected members. Nominated members are not considered in the electoral college, be it in assembly or be it in parliament. We have 2 nominated members in Lok Sabha and 12 nominated members in Rajya Sabha. These nominated members do not participate in elections of the president. We have only elected members who participate in the elections of the president. Similarly, in assembly also, we just do not consider the nominated members. We consider only directly elected members. So, to have a equal representation, to have a uniformity and equality, to have a parity, we would come to this value of MLAs. So, value of the MLA is calculated this way: total population of the state by total number of elected members in the legislative assembly into 1 by 1000. This is because we have a population which is in lakhs and total number of MLAs will be in hundreds. So, to have a parity in that, we would be adding this 1000 to the denomination. So, this is the formula where we will calculate the value of MLA. Again, this value of MLA is also important to calculate the value of the MPs. So, here the procedure is, first the total number of votes cast by all the MLAs are counted. Once the total value of the MLAs are counted, then that would help to know the value of the MPs, that is member of parliament. Again, these value of the MLAs will be divided. So, we will take the total value of all the MLAs of all the states. Will take that total value and will divide the total value by the number of elected member of parliament. So, both Lok Sabha and Rajya Sabha, we will try to calculate that by dividing this total number of votes, that is value of all the MLAs of all the states, divided by the total number of elected MPs. So, this will be the next formula. So, here the value of the vote of an MP is, we have got total value of all the MLAs here. First is we will count in a one state, then similarly we will take all the states into consideration. So total value of votes of all the MLAs of all the states, this figure is like around, we have 4,120 MLAs in India. So all states we have around 4,120 MLAs, and we will get the value depending upon their population. So this is the total number of MLAs. We have total number of elected members of the parliament. We have around 776 elected MPs in the parliament, both Lok Sabha and the Rajya Sabha. So the first we will calculate the vote, that is value of the vote of MLAs, then we will add all those values, and that value is put here. So total values of vote of all MLAs divided by total number of members of the parliament, elected members of the parliament. Here we will get the value of MP. We will get the vote value of the MP. So this first formula, that is when we say the value of MLA is calculated by first taking the total population of the state, then the number of elected members of legislative assembly into 1 by 1000. This formula, that formula ensures that it gives weightage to the population of each state, because as we know, the population of Uttar Pradesh is larger. We have most of the population in Uttar Pradesh. Then we have smaller states also, like we have northeastern states, Sikkim, Nagaland. We have states like Goa also with very less population. So to give weightage to such states, we derive this formula. So every state should have an equal proportionate representation, and that is why we use this formula to ensure that all states are represented according to the proportion of their population. So first formula is used to give weightage to the population of each state. And in second formula, that is here we have calculated the value of vote of MP, that is member of parliament. Here we would ensure that there is a parity. There is a parity between the votes of all MLAs and all MPs. So there would be a parity, because here we are in this formula, we are dividing the value of total MLAs by the total members of parliament, elected members of the parliament. So to ensure that there is a parity between the value of votes of both MLAs and MPs, we use the formula number 2, that is value of votes of MPs. So this 2 formula ensures that first we have a representation of all the states according to their population, and second thing is where we have parity between MLAs and MPs. Then we will calculate a quota, electoral quota. This is again important formula. Generally, if there is a single contendant, there is no need of calculating this quota, because unanimous elections could also held, or if there is 2 contenders, then whoever gets the majority, absolute majority, will be eligible for the post of president. But what we have 4 members and no one has ensured absolute majority. In that case, we would be applying this formula, that is total value of votes by number of the vacancies. Generally we have 1 vacancy, that is 1 president, and 1 elections are held for only post of the president. So number of vacancy is 1 plus 1, which is divided again, which is have plus 1. The total value should be added by plus 1. So this goes where quota is total value of votes by number of vacancies. Here we will be having 2, then plus 1. This is the formula of quota. For example, we have total value of vote goes to 9,000, then it is divided by 1 plus 1. This is 1, it is divided 1 plus 1, that is here the number is 2, total number is 2 plus 1. So this will be the quota of the president, the contender. Whoever gets this value will be declared as winner. So that was the process of elections. We should remember and understand these three formulas. One is counting the value of MLA, then we would be knowing the value of MP, then electoral quota for the president. So these three formulas would ensure that there is a representation, there is a representative parity or equality, uniformity among the states. All the states are represented according to their population, proportion to their population. And second is to have a parity between MPs and MLAs. We would be using the second formula. So we may have many doubts that what if there is any problem, or what if there is a vacancy in some states. So we can say that if there is any problem with the electoral college, or if there is any vacancy in the assemblies, or if the assembly members are suspended, such disputes should be decided by Supreme Court. So Supreme Court is the only authority where such disputes would be settled. As we know, Supreme Court in various judgments have also said that whenever there is a vacancy in any state, for example, in 71 or such elections, we had Gujarat assembly dissolved. Supreme Court said that there is no need to postpone the elections. No matter if one state is dissolved, we can go for the elections. And that is a total, no, there was no assembly in Gujarat. And we also have that in electoral college, some of the MLAs would be suspended. So suspended MLAs or MPs could also participate in electoral college. So irrespective of the vacancies in legislative assemblies or the parliament, the electoral elections to the president would go on, and no one should go to the court saying that because of the vacancy in particular assembly or parliament, the elections should not be conducted. So there was a clear ruling by Supreme Court that doesn't affect the election process of the president. And the election of person as a president cannot be challenged on the ground that the electoral college is incomplete. As I said, if there is any vacancy also, the elections to the president would be held. So this was the elections to the president, very important process, very lengthy process also. If there are more than two contenders to the post of elections, there is a preference votes, there are the transferable votes, which is a continuous process until we reach the quota. The numbers would go on, the transferable votes would be go on. So that depends upon the preferences. A voter can have preferences before the name of the contender. Definitely first preference is mandatory. The voter should give a preference, that is first preference. Other preference is up to their wish, but the second preference is given to the second contender who is in the election process. So మనకి రాష్ట్రపతికి కావాల్సిన అర్హతలు, what are the conditions or qualifications needed for being a president. So first, president should be a citizen of India. That is a mandatory. President should be a citizen of India, both a natural citizen or naturalized citizen. He has to be a citizen of India. Should have completed 35 years of age. So the qualification of the president is, ప్రెసిడెంట్ కి 35 సంవత్సరాలు నిండి ఉండాలి, మనకి భారత పౌరసత్వం అయి ఉండాలి. సో there is no education qualification for the President of India. The Constitution has not mentioned any educational qualification, but one qualification is the President of India should have qualified for the elections of the Lok Sabha. So that is the only qualification what the President of India should have for contesting the elections. So qualified for the member of the Lok Sabha. And one thing is the president should not hold any office of profit, or if the president is MP of either Lok Sabha or Rajya Sabha or MLA for that matter, he or should resign before entering the office of the president. So they should not hold any official position or office of profit. So they should not hold any office of profit, but they have to be qualified for the qualification of contesting elections to the Lok Sabha. And the contestant, the candidate, should not be a member of either house of the parliament, that is both Lok Sabha and Rajya Sabha. So there is a clear qualifications mentioned for the election of the president. So here the president, once the president is elected, he or she has to take oath. Here the Chief Justice of India would generally take the oath. Here president has to make and subscribe to oath or affirmation. So President of India would take oath. So to faithfully execute the office, this is the thing what the President of India has to take oath, to faithfully execute the office, to preserve, protect and defend the constitution and the law, because the president is the highest dignitary of the nation. He is the first citizen of India, and he has the responsibility to ensure that every act should be consistent with the constitution of India. So he should preserve, protect and defend the constitution and the law. And in oath he would also say that devote himself to the service and well-being of the people of India. Here the people of India is important, because the president is the president to the entire nation, entire people. The president represents the unity, the sovereignty of the nation, the integrity of the nation. So the main responsibility of the president is to protect and defend the constitution and to serve the people of India. So here what are the conditions? We have talked about qualifications. We have few conditions also. కొన్ని షరతులు కూడా ఉన్నాయి ప్రెసిడెంట్ ఆఫ్ ఇండియాకి. సో ప్రెసిడెంట్ ఆఫ్ ఇండియా అయిన తర్వాత హీ షుడ్ నాట్ బి అ మెంబర్ ఆఫ్ ఎనీ హౌస్. ఒకవేళ అతను మెంబర్ ఆఫ్ ద పార్లమెంట్ ఉన్నా ప్రెసిడెంట్ అయిన తర్వాత వాటిని వికెట్ చేయాలి. సో హీ షుడ్ నాట్ బి అ మెంబర్ ఆఫ్ ఈదర్ హౌస్ ఆఫ్ ద పార్లమెంట్ ఆర్ హౌస్ ఆఫ్ ద స్టేట్ లెజిస్లేచర్. Once the candidate is elected as the President of India, obviously the person should vacate or resign to the post of MP or MLA if they are. So if any such person is elected as President, it is deemed to have vacated his office of MP or MLA from the day on which he takes the oath. So that is a condition what we have mentioned in the Constitution. And the other thing is, he should not hold any other office of profit. He should not be part of any organization. He should not hold any office of profit. So this President of India will be entitled with house, that is we have Rashtrapati Bhavan in Delhi. It is a residence of the President. So he is entitled without payment of rent to use his official residence. We know Rashtrapati Bhavan, which is located in Delhi. So all those emoluments and allowances cannot be decreased. Whatever the emoluments or allowances, salary provided to the president should not be decreased during his term of office. During the term of office of the president, whatever emoluments is mentioned, that shall be continued. And he is also entitled to allow many emoluments and privileges as determined by the parliament. Here Constitution has given the power to the parliament to decide on providing emoluments and allowances to the President of India, because everything is not mentioned in the Constitution. Here Parliament has brought many laws regarding the conditions of office to the President, and also decided on what privileges should be provided to the President. So what is the term of President's office? See, generally we have 5 years of term. This is a fixed 5 years of term to the President. Once he is elected, from that day we have 5 years, and the President of India can also be re-elected. That is, there is no condition that there is no limit on the term of the president. As in United States of America, we have seen that a president shall be elected for 2 terms only, not more than that. The maximum term of president of United States is 10 years, but generally because we have fixed 4 years of term, the president of United States of America could get elected only twice. Only twice the president of America can be elected. That condition was not mentioned in our constitution, but there was generally a precedent followed. There was generally a precedent followed that the Indian president should also get elected for maximum of 2 terms. Though we did not mention this in our constitution, but there was a bill passed. There was a bill passed in around 1970s in the parliament by a Communist Party member that the president of India should also have a fixed tenure of 2 terms, that is maximum of 10 years, because we have 5 years of term. Though that bill could not pass in the house, but we have accepted the precedent that generally our president should also have a tenure of 2 terms, that is only twice he could contest the elections. But history says that only the first president of India, Dr. Rajendra Prasad, was re-elected, and he is the only president who had continued for 2 terms. So this term is generally there we say that eligible for re-election. There is a precedent here followed, and a maximum of 2 elections or a president could contest for 1 more time. So his office can be terminated either. We have few procedures how the president could be terminated. One is when he completes his duration. When the president completes his term of 5 years, then there would be elections conducted for that post before the expiry of the term. That is, at least 60 days before the expiry of the term, there have to be an elections conducted for the post of the president. And if the president resigns, by writing to the vice president, the president gives his resignation to the vice president of India. This is an important question here. Generally the question is framed in this way. To whom the president of India would give his resignation. So it is the vice president, which is the vice president is been addressed for the resignation of the president. So we have 2 things. One is when the president of India completes his term of 5 years, then he can be go out of office when he gives his resignation to the vice president, or the president can also be removed for a grave constitutional mistake, or if he violates the constitution. If the president of India violates the constitution, then only the president of India is removed, and this process we call it as impeachment. Impeachment is a process which is a very complex process in the parliament. By this process, the president of India could be removed from his office before completing his term or on the ground of violation of the constitution. So the term of president's office, though we say that it's fixed for 5 years, but in certain cases, if there is a violation of the constitution by the president, he could be impeached. This we haven't seen in our case. So the president can be removed for the violation of the constitution. So how the process of impeachment starts? So what is the process of impeachment? Impeachment is a process where the president is removed from the office before the expiry of the term of office. Though impeachment can be initiated in either house of the parliament. As we know, both in Lok Sabha or in Rajya Sabha, the impeachment bill can be introduced in either house of the parliament. The process may start in either house of the parliament and where the process has initiated. For example, let us take that in Lok Sabha we have introduced the bill for impeachment of the president. So that bill has to be signed by 1/4 of the total members of the Lok Sabha. So before introducing the bill only, that bill should have a support of 1/4 of the members. That is, 1/4 of the members should sign the impeachment bill. And once it is signed and introduced in the Lok Sabha, it has to be passed by special majority. So once the bill is introduced in the Lok Sabha, generally the impeachment bill can be introduced in either house of the parliament, that is both Lok Sabha and Rajya Sabha. But for our example, we are taking that suppose we have introduced the bill in the Lok Sabha, we should have 1/4 of the support to the bill, and that bill, if once introduced in the Lok Sabha, should be passed by 2/3 of the majority. That is, we call this as special majority. Once the impeachment bill is passed in the Lok Sabha, then that bill goes to the Rajya Sabha. Here the Rajya Sabha will act as an investigating agency. It will become a quasi judicial body. So what all the allegations or what all the basis grounds for the removal of the president, that particular house, the second house, will discuss on the process of impeachment. So the Rajya Sabha here in our example, the Rajya Sabha will become a quasi judicial body. It will become an investigating body, and it will investigate on the charges mentioned on the president or charges alleged on the president. So here the process is a quasi judicial body. In the process of that investigating, the president can also participate. So the Rajya Sabha can call upon the president in the process of that inquiry or investigation. So we have a notice generally here. We have a notice before impeachment. A 14 days prior notice should be given to the president. This we have discussed. It should be signed by at least a quarter of the total membership of that house, that is 1/4 quarter of the total membership of that house, and a prior notice of 14 days should be given to the president. So a resolution to impeach the president be passed by a special majority. As I said, special majority is 2/3 of the majority. Once that majority passed in one house, that will go to second house, which will investigate the charges. This we have discussed. When we say originating house, it is the house in which the impeachment bill has been introduced. So originating house, after passing that bill by special majority, that is 2/3 of majority, the other house, the second house, would become as a investigating body or quasi judicial body. So the charges are investigated in the other house, and here the president has the right to defend oneself in that particular house. So if the second house also, that is the investigating house also, passes the bill by finding all those charges, if the second house also passes the bill, then from that time the president is impeached. So again that particular house also should pass the bill by special majority, that is 2/3 of majority, and if such house passes this bill, the president is deemed to be impeached. Otherwise the bill will not proceed. So the bill will become invalid if the second house could not find the charges leveled on the president as baseless. Then if the bill is not crossed this or not passed this special majority, then the impeachment procedure would be halted there. But generally if the second house also passes the impeachment bill with the special majority, then the president is impeached. So for the removal of president, the process of impeachment, we haven't used that, but the process of impeachment is very complex, and there is no other process other than the impeachment to remove the president. The president will generally not in the office, or if he is ill, then the vice president would take the office or in charge of the office of the president. So we know that no president till today has been faced this impeachment process, because that shows the vibrant nature of Indian democracy. That shows the very much maturity of Indian democracy. So only for the grave violation of the constitution only the charges of impeachment would be levelled, or the impeachment bill would be introduced in either of the house. So this is a small flow chart where we say that the impeachment bill is introduced. Okay, we'll discuss the powers and functions of the president, or before that we say in what conditions there will be a vacancy generally happens in the president office or office of the president. One is when the president dies in the office, then there will be a vacancy to the president's post when he dies in the office. Otherwise, or when there is election which is disqualified, or the Supreme Court declares the elections of the president as invalid, then only there creates a vacuum in president's office. But here we have one condition: whatever the act done by the president during his term, that is before the Supreme Court declaring the election of the president as invalid, those acts are to be implemented. So those acts does not become invalidated. So whatever the decisions taken by the president before disqualifying, those acts would be in place. So that is one thing we need to understand. So this is another thing. We have Article 53, very important, that is executive powers are vested in the president. So who is the head of the executive? Head of the executive, that is president. President is a nominal head. He is the head of the nation, head of the state. And when we say head of the executive, it is the president. As we know that the Council of Ministers is headed by the Prime Minister. Prime Minister is the head of the government. But all the decisions of the government should be passed by the president. President has to sign on those bills to become an act. So head of the executive, and being a head of the executive, president has many functions or different types of functions the president has. The president is very powerful in terms of all those functions. For example, the president has administrative functions, the president has legislative functions, emergency functions, defense related functions. So there are many functions which is provided for the president. And when the president functions, or when the president has those executive powers implementing, the president is not answerable to any court in the exercise of his powers. This is because the president do not act on his own. Though the president has some discretionary powers, but most of the powers of the president would be functioned, or the president would act on the aid and advice of Council of Ministers headed by the Prime Minister, actually which is a real executive authority. When we generally say in parliamentary system of government, we have nominal head and we have a real head. Real head is the Council of Ministers headed by the Prime Minister. Prime Minister is the real head, and here the president exercises his functions based on the aid and advice of the Prime Minister. So the actions of the president are not answerable to any court. There should not, no person should go to court questioning the functions of the president. Here the president enjoys few immunities also, both personal and legal immunities. So when we say immunities, the court generally do not punish a president when he is in the office of the president. He will enjoy many immunities. So the president is also armed with enormous powers. So what are these powers? What are the immunities given to the President of India? So President of India cannot be arrested. President of India cannot be questioned in the court for the action when being a president. So the president would enjoy many immunities. So what are the functions the president have? So this we will be discussing in our next class. We will discuss the various powers of the president, and we also analyze the factors which are related to the president. Thank you for watching my video.